You have the first case in front of us today, and that's State of Ohio versus Lopez and T-Bond Surety. You both know, you've been here many times. You're welcome to come back anytime. Anyway, you have 15 minutes each, and the appellant may reserve up to 5 minutes, but I would remind both attorneys, I don't think there's a problem here, but I would remind both attorneys not to use the real names of minors or not to use the names of victims. Please refer to them as a victim, the child, or as an initial or something in that order, just so we don't disclose the identity. As you know, we are being recorded and we're being broadcast live as well. So we need to keep our voices up and just be able to hear each other. And then if you're not speaking, please mute yourself. Okay, Ms. Bremke, are you ready to proceed?
I am, Your Honor.
Okay.
Giovanna Bremke on behalf of T-Bond Surety. T-Bonds posted a bond for Mr. Carlos Lopez. His was a case that was bound over from a municipal court, and he failed to appear at his first arraignment at the Common Pleas Court on December 1st, 2014. That resulted in a warrant being issued, and the surety was not notified, nor was a show cause hearing set until March 29th, 2019, which is actually 4 years, 3 months, and 28 days later, a show cause hearing was set. It was continued various times and ultimately ended up in November of 2020 with a judgment being entered against my client T-Bonds. There's 2 assignments of error, and both of them are very specific to the statute 2937.36, which is the forfeiture statute. So this statute, and I quote it in my brief at the top of page 5, but it has a notice requirement, and I want to be specific because there is a case out of this court, an Amanda Lee case, and it's a 2012 case, but it's become a real problem for sureties, and it is actually based on a prior statute. So right after the I believe it was right before the Amanda Lee case was decided. It was actually in 2011, the statute changed, but Amanda Lee is based on the prior version of the statute. So now we're dealing with a new statute, and there are significant changes. There's a 5th district case, which I cite, State versus Lott, that sort of goes through those changes. But they essentially have to do with 2 things. The prior version of the statute had no notice requirement. This version of the statute says that within 20 days of a forfeiture, there has to be notice to the surety, and the notice is specific, and the notice is twofold. 1, it has to give notice of the forfeiture, and 2, give notice of a show cause date that's set between 45 and 60 days. And the second thing that the statute changed is that I forget, the prior version of the statute may have only been like 20 days to set the show cause, and this one gives between 45 to 60 days. So it extends the time that the show cause can be set, and it also adds a notice requirement. Again, in this case, it was set much beyond that. It's 4 years, 3 months, 28 days later, a show cause hearing was set. And I want to bring up a couple of things that the state mentions in their brief, specifically to the first assignment of error. The state.
Before you go there, can I ask a quick question? I just want to make sure of a fact. There was the no-show for the arraignment. And a warrant issued. Was the bond forfeited at that time, or just nothing was done with the bond?
I believe the bond was forfeited and there was no notice.
Okay, I figured that, but I wanted to make sure. Okay.
Yes. So, the state contends actually for both assignments of error that they should be reviewed under plain error. These issues were raised in a brief that was filed, I believe, October 7th. They're there. The issues were reserved for the record, and that's all in the record. The state also brings up some case law that this is discretionary or directory in nature because there's this notice requirement and when they're directs, they've got this long line of case law. But what I would bring to your attention is this is a bond law is criminal quasi-civil. So this is a big deal to enter a judgment against somebody. In no civil case would you enter a judgment with no notice, no limitations for the notice. And the statute specifically, and again, this was contemplated when the legislature changed the statute to allow for the 15-day notice. And I think the state sort of loses some sight of what that notice has in their brief or what that notice has to be, because the state argues that my client had constructive notice because they did appear at the show cause, 4 years later, 4+ years later. But that notice, again, is twofold. It's a notice of the forfeiture and a notice of the hearing. So there is a requirement of the notice. It's not just a notice of the hearing. It's also notice that the bond's been forfeited.
Counsel, how do you balance that with the duty of the surety? I mean, we're talking about a span of years here. I mean, at what point was it the duty's surety to say, gosh, this person that we bailed out didn't even show up for the first arraignment. We'd better do something about it. Isn't that what's behind the word surety?
Well, arguably, yes, both parties have some sort of obligation, but the legislature, again, explicitly puts this obligation on for notice on the clerk. And I think that the reason behind that, and that sort of goes to my second assignment of error, because I raise a lot of issues in the second assignment of error of why it's important to have that show cause hearing between 45 and 60 days. And the reason for that, and again, it's public policy, and it's bad policy to let people who are charged with serious offenses run on the loose. It puts law enforcement at risk, and it gives them a time to have a jump start outside of their pickup radius. So these pickup radiuses, once they get outside of that, the surety cannot pick them up, and that puts the surety at a higher risk than they contemplated. And so while I'll acknowledge that maybe there is some responsibility on both sides, I think that the statute is here as a safeguard for the public, so that in the event, nobody's perfect, that the surety doesn't notice that this person is missing. And quite frankly, years later, they may have just assumed that the case is resolved, because most cases don't end up in a KPS or forfeiture. So this is a safeguard, again, for the public, and that's what the legislature intended, and it is very explicit in the statute of what the notice requirement is, and it has to have a date certain of the show cause hearing. Now, I'll even further point out that the state acknowledges, so the state drafts the entry, the entry that ultimately produces the warrant in this case. And the state, it's essentially a fill-in-the-blank type entry. And the state acknowledges where the fill-in-the-blank is. There's sort of like show cause will be set, blank. And there's an asterisk, and it says that this date has to be within 45 to 60 days. So again, the state's acknowledging in that entry, the very entry that results in the KPS in this matter, that it has to be set within 45 to 60 days. And it's not followed, and that's their own entry to be construed against them. So again, I think it's important to distinguish that this change in 2011 to the statute is very specific. It's a shall, number one, 2, it says that the notice has to be twofold. A notice of the forfeiture, and I think that's significant because that sort of goes to Judge Callahan's issue that, this isn't just, hey, you have notice of your hearing to show why you shouldn't have a judgment, but it's also, this places on the clerk's notice that to notify the surety, start looking for this guy. Here's the, forfeiture. It's a very tight time. 15 days is one of the more limited timeframes in the law. And I think that's intended for public safety. Because again, it's very dangerous for law enforcement to go pick people up on warrants when they already know that they're going to be incarcerated. It's dangerous for law enforcement, it's dangerous for the public. So I'd reserve the rest of my time.
Thank you. Attorney Murphy?
Thank you, Judge Carr. Good morning. Good morning, Judge Callahan. Good morning, Judge Sutton. I'll begin with the first assignment of error, which goes to the notice basically never being provided to the surety, let alone within the 15-day period, as T-Bonds argues here. I'd first point.
Mr. Murphy, I almost called you
Yes.
Judge Murphy. I'm sorry. where you just started, can I ask you a question?
Absolutely.
If our decision was, or if a finding was that shall mean shall, and I understand what you laid out methodically in your brief, but if shall means shall, is this case over with right there?
I think so.
Okay. Well,
Yeah.
I'll let you go ahead with your discretionary argument.
Well, and Judge, I mean, it does say shall provide, but here, provide the notice, but I'll jump ahead here. The notice has to be provided by the clerk of court, as was pointed out already during oral arguments. And what that does is show us that if it's not provided within that 15-day period, you then can't take jurisdiction from the court over this matter. If there's an administrative error, that just doesn't, that's not sensible and reasonable to say that within that 15-day period, if the notice doesn't go out, now the court can't hold the bonds person responsible.
Okay,
Judge Carr.
let me just ask you a question. I guess I want to make sure I'm understanding what you're saying. So you're saying that the court nor the prosecution, specifically the prosecution, the state, has any duty in regard to the notice?
That's my reading of the statute, Judge.
So the clerk of court is the one that's supposed to, I know you're not required under the statute, obviously, to send out, that the clerk of courts would always be sending the notice. But what I'm getting at is, so the clerk of court is the one that's required by statute to monitor everything and make sure that the notice goes out.
2937-36C says a magistrate or the magistrate or clerk. And through my research into, and I didn't spell this out in the brief, but I don't believe that the word magistrate, as defined in the revised code, as I looked back through what magistrate means in certain sections and divisions, would not include any, in this case, the judge. It would be very specific to, as I recall, like county courts or something to that effect.
Okay, I can appreciate that. I'm just trying to figure out, when we were talking about who has an interest here and everything, and the interest in the safety of the public, it seems to me like the state should have an interest in that, with the prosecution bringing the charges on behalf of the citizens of Ohio. It seems to me like the state, just as common sense, should be looking at the bond forfeitures and making sure that if somebody has not shown up for court, that notice is sent out.
Let me distinguish here between, I think it's an important distinction between public safety and bringing a person to court. certainly the law enforcement would be acting upon the warrant, but that's not a self-interest action. What the bonds people, in this case, the surety T-bonds, is really acting is a self-interest. Let's be honest, at its base level, this is self-interest for T-bonds. It's a financial interest. They have no concern, I don't believe, with public safety, and the public safety isn't changed whether that 15-day notice goes out or not. And as far as, you know, we've heard talk about pickup radiuses and you know, first of all, that's not part of the record. We have no idea what the pickup radius is. Second of all, I'm not, the bonds person is the surety, as far as I'm concerned. As far as I know, from the state's point of view, the surety has no pickup interest. The surety's interest is going to get the person. They can go nationwide and worldwide, as far as I know, to go bring back the person that they've insured would be in court. I'm not aware of anything that says differently, but again, it's frankly immaterial because it's not part of the record here. The 15-day notice is a discretionary period in the end, in which shall doesn't really mean shall. Shall means that the notice really should go out. As far as the date period in which it goes out in, it's directory in order to maintain the order of these proceedings. Did the order of these proceedings kind of get out of hand in this case? Yeah, obviously I wrote down here beforehand the 5-year, 4-month period almost, certainly, but the state suggests to the court that, you know, again, not part of the record, but if you ask the surety today, if it had even looked into and known where Mr. Lopez was 15 days, 30 days, and 15 months and 30 months after this all, after Mr. Lopez never showed up for his arraignment, T-bonds had no idea.
Counsel, could I direct your attention, not to make a pun, but direct your attention back to my original question in regard to the state's responsibility or any duty. I just want to make sure that we are clear for the record, you know, because people do watch us, which is a nice thing, a good thing, that you are right. A warrant would issue and law enforcement would be on the alert that this person is missing. So it's not like nobody would be looking for them, but yet at the same rate, the surety, like you said, has a self-interest because they have actual money on the line.
Right. When Mr. Lopez didn't show up for the arraignment in December of 2014, there was a warrant issued for his arrest for failing to appear. So there is that law enforcement aspect to it. But don't forget, if law enforcement were to have found him 2 years later, the surety, in this case T-bonds, is still on the hook for this. They didn't do anything to find him, and they couldn't rely on, as far as some case law that I saw, they couldn't rely on law enforcement having found him. If memory serves, I believe it was the Lee case in which the state found the defendant, and the court said that the surety in that case was still on the hook and affirmed the order that the surety needed to forfeit the bond because it was the state that found Miss Lee in North Carolina and not the surety.
Was that initial notice an issue in the Lee case?
I believe it was.
Okay. They start running together.
Yes, they do. And I'm not going to answer. I can't.
That's
I should
okay.
say I can't answer that definitively. but what the period aims to do is to maintain some kind of order in these proceedings. It's not like a speedy trial statute in which the General Assembly, the legislature, has said you're free. You have to release the defendant. The case gets dismissed with prejudice, and you can never prosecute the person for the crimes when there's a speedy trial violation. In this case, there's nothing to that effect reflected in 293736.
Counsel, let me ask
And-
you. Counsel,
Sure.
let me ask you if you don't care. What is the purpose then of the notice? I mean, if it's merely directory and it can be given 20 years later and the surety is going to be responsible for it, why even have a notice requirement?
Well,
Even if it is directory.
Well, the reason you have it is that you want to give it. I mean, the reason you have it is because it should be given, and it's to maintain that order. Now, 20 years, is that maybe going to change the analysis? Maybe, it might, but in this case, I guess just to answer your question is, Judge, you're expecting that it's going to happen. You're thinking of things that are going to occur as the law is written. And in the instances you hope like this one that are not going to occur frequently, they're going to be infrequent. There's still notice. And frankly, if the surety's doing its job, then 5 years later, one, it should never get to that point. And the surety will be able to provide that good cause, knowing that the person didn't show up for court. But two, the court's telling now the surety, I guess through the notice to answer your question, Judge, like, look, you got to do this. You've got to show cause by a certain date. And let's be clear about something, jumping ahead to the second assignment of error. There is no requirement that a hearing date be set in the 45 to 60 day period. This court has said that. The assertion that there is a requirement for a hearing date is not correct. It's wrong. The fact that a surety fails to show cause by a date 45 to 60 days from which the notice is sent out triggers the requirement of a hearing. Failing to show cause now says we're going to have a hearing to give you that second aspect of due process. Going back to the first assignment of error just briefly, Judge, there's also this requirement of prejudice that this court has recognized under Appellate Rule 12D. And whether there's notice or not, in this case, the surety came into court, which from the state's perspective operated as a waiver. The surety entered an appearance through an attorney before the hearing date that had been set of April 15th, 2019. And once the hearing actually occurred in April or November of 2020, the surety and its legal representative surely had actual notice of that hearing occurring. With regard to the show cause hearing date, again, the state I stress, I guess the state can't stress enough, the word hearing, I don't know that the word hearing appears in 293736C. I'm not going to say it doesn't, but I'm pretty sure it doesn't. What it requires is a 45 to 60 day period. In that period, a date certain by which the surety needs to show cause. As I pointed out in the brief, if the surety were to get that notice and the next day having done its job, knew that the person was not going to show up for court because they died, they could simply send a motion with an affidavit attached, the death certificate saying this person's dead. We don't need a hearing to do that. We don't need if the surety finds the person 3 days later, they certainly aren't going to want to wait 60 days. Let's say that a hearing date were set 60 days out. They're not going to want to wait 60 days to show cause. They're going to bring that person in front of the court as soon as possible to show that the surety has done its job of ensuring the person's presence. They wouldn't want to give that person that, extra month or two to abscond again. The good cause, and this is what I think.
And counsel,
yes,
counsel, you are out of time.
Okay.
So, thank you.
Thank you, Judge. We just asked that you affirm the trial court's decision.
Thank you. And you do have 5 minutes remaining, Ms. Bremke.
Thank you. So I want to address the issue of the law enforcement being able to pick up on the warrant, and that doesn't prevent law enforcement from being able to pick up. And I think that this is important because what I found when I started representing sureties is that I didn't know a lot about this area of law, and I think that it's a big part of our justice system that a lot of people don't fully understand what happens with sureties. So while, yes, a law enforcement officer could pick someone up on this warrant, we have sureties for a reason, and it's not just to extort money out of them, because law enforcement can do the same thing. So why do we just have sureties just so we can get money when someone disappears? That's really not the case. And, there's a lot of things that the surety can do. For example, in this case, this individual is still missing. That's from 2014. But there's things that the surety will do. Law enforcement won't actively go out and look for this individual. The surety has access to co-signers, to other individuals. When they post a bond, they take in an application, they have other individuals that they can contact. And again, that goes to their harm, where 4 years later, grandpa who co-signed may be dead, or moved away, changed a phone number, things of that nature. So it's the surety's role, and they have greater access than law enforcement to be able to locate this person.
Excuse me, isn't that all the more reason why the surety should be checking the docket?
And again, I'll acknowledge that perhaps there is, some sort of, mutual issue here. And just as the state should be asking for this individual to be picked up as well, because they certainly have an issue, and everyone sort of has a stake in this person being picked up. But the statute requires only one person notify, actually two, the magistrate or clerk. So, and that's there for a reason. So again, there's sort of a safeguard that in the event that it slips through the surety's cracks, the state wasn't on the state's radar until they filed their motion 4 years later. That's why the statute specifically places this on the magistrate or clerk in order to notify the forfeiture. There's other things that the surety can do. For example, the pickup radius. That is a big thing, because these pickup radiuses tend to be very small. So a surety can go and ask, if they know the person's in California, they can go ask the state to extend that pickup radius. If they get picked up in California, they're not going to get extradited back, because these pickup radiuses tend to be very small.
But that's not part of the record in this case, correct?
No, but it's an important public policy issue, because we're talking about the role of the surety and why they're different than just a law enforcement officer picking up on a warrant. And there are roles that they can do, and they actively pursue these people, whereas law enforcement are just going to wait for them to pop up. And if they do pop up outside the pickup radius, they're not going to be able to get them. And the surety's not going to be able to get them either, because it's actually kidnapping. They could get charged with their own criminal offense for picking these people up outside of the pickup radius. So I think that they serve, they're not just there so that we can get money out of them when these people go missing. They serve an important role, and it is a public policy issue. And like I said, I think everyone should have a stake in this. The court in wanting these people back, the state and the surety. This individual the charges are gross sexual imposition. So this is an individual that you wouldn't want out there to commit another sexual offense, potentially. So, I think the state even acknowledges when asked, why even have this notice requirement? And I think the answer was because, you should give the notice. And again, that's because it's good policy. So again, if there's no more questions, we just ask that you reverse the judgment. I think the statute is very clear, and it's very clear on what it has. If we're not going to follow it, again, what's the limitation? The sort of the state's argument is, hey, if we miss the 15-day period, then the sureties are just out completely. That's not fair. But the surety's argument is, it's not fair to come after us 100 years later for these individuals as well. So it goes both ways, but there's only one way in which it says in the statute, and that's the 15 days.
Thank you. Thank you both for your presentations, the arguments this morning. We appreciate them, and we will take the matter under advisement and issue a written opinion that will be sent to both parties, as well as it will be released, obviously, on the website. So thank you again, and I hope you have a good rest of your day.